right? It includes residential and non-residential space leased out by the landlord, leased out by the landlord, and to perform amenities. Now, what is amenities? Amenities includes your gates, windows, right? Or like, let's assume you have provided some additional things. Like, let me tell you, there are attached wardrobes, right? So these things can be considered as amenities, which are provided to enjoy that particular property at fullest. Now, forming part of agreement between them or any land which is not being used for agricultural purpose. Now remember, this definition is inclusive in nature. So it is stating that all the leased property which is not a agricultural property, which is not going to be used for agricultural purpose on that particular property, whether it's residential or non-residential, it shall fall in the definition of accommodation. Abhi, when we will follow this act closely, so we will realize there are certain exceptions to this thing, right? The government property is exempted and all. But as of now, what we have to understand, any property, either residential or non-residential, leased by the landlord to the tenant. It includes open space like porch, balcony area, staircase, ground, garden, garage, and all the other facilities and amenities forming part of the agreement between the landlord and tenant. And if the property is not agricultural, is not getting used for agricultural purpose, it is accommodation. So tell me whether the definition of accommodation is clear, yes or no? Just let me know. Is it clear? Yes?
Yes, sir.
Yes, sir.
Perfect. Perfect. Now, next, agreement. Agreement means written agreement executed by the landlord and tenant as required under this act. So it is very much simple. Here, agreement refers to rent agreement, right? So in Chhattisgarh, what is rent agreement? An agreement signed, okay, between landlord and tenant, right? For the purpose of this act, that is known as agreement, right? Now, district means the district constituted under Chhattisgarh Land Revenue Code CGLRC. Now, habitual offender. Here you have to remember, if you are having parent, you can mark it. If you are not having, you can write it in your notebook or somewhere. Habitual offender means a tenant who fails in a period of 12 months on 3 or more occasions to pay the full rent and all dues to the landlord, and on the due date in accordance with agreement. So what is the habitual offender means? It means in past 12 months, right? Immediate past 12 months, right? Or in any other span for that matter, right? The person hasn't paid 3 months rent plus whatever the maintenance charges are there or whatever charges are there, right? He hasn't paid that amount. 3 months rent plus all the dues to the landlord. Okay, on the due date, okay, in accordance with the agreement. So, like there is a rent agreement, and as per the rent agreement, let's assume that I have to pay the rent of 8,500 per month. I may default in 1 month. Then I paid rent for second month, third month, fourth month. Then I made default in fifth month. Then I paid for sixth, seventh month, and then I defaulted in 8 months. I shall be considered as a habitual offender. It is not stating that these 3 months should be consecutive, one after another, right? So within the span of past 12 months, if you haven't paid the rent for 3 months as per the terms of agreement, plus all other dues like maintenance cost or security cost, whatever is there, it shall be considered you are a habitual offender. Now, Heading towards the next definition. Now, from prelims point of view, I'll tell you the question. What you have to understand. Obviously, the definition clause, agreement, accommodation is in 2 clause 1. It includes open space, staircase, garden, ground, garage, and all other facilities. They ask the question, which of the following is not included in accommodation, right? So you have to remember it. Secondly, accommodation include residential and non-residential property. Next, you have to remember agreement is in 2 clause 2. Agreement means written agreement executed by landlord and tenant. There is no challenging thing to understand this definition. Habitual offender, you have to remember the period of 12 months and default of 3 or more occasions. So this is the thing you have to remember from prelims perspective. Now, coming to landlord. Landlord means landlord doesn't include only the landlord. It includes some other people also. So we are going to discuss by the definition. Landlord means a person who for the time being is receiving or entitled to receive. Remember that they are not stating that you are receiving. Sometimes what might happen that tenant has become default, right? And he hasn't paid rent. It doesn't mean that you are not a landlord anymore, because you are entitled to receive that money. You are not receiving is a different thing, but you are entitled to receive. So landlord means a person who for the time being is receiving or entitled to receive the rent of any accommodation. Rent of any accommodation, whether on his own account or on account of, or on behalf of, or for the benefit of any person as a trustee, guardian, or receiver for any other person who would so receive the rent to be entitled to receive the rent if the accommodation were lent to a tenant. Simple. यहां तक की बात क्लियर है कि landlord means someone who is receiving or entitled to receive rent. Point number 1. So what we'll do, we'll just write point by point. Now, point number 1 is who is a landlord? Who is receiving or entitled to receive the rent. Second, okay, obviously for accommodation. Now, second thing shall include whether on his own account, on his own account. Second, third, on behalf of, okay. Fourth, on account of, on behalf of, okay, or for benefit of. 5. So in total there are 5 things. Landlord means person himself receiving rent, right? Second, on his own account or on account of another or on behalf of another. Okay. Now, whenever you are receiving rent on account of or on behalf of another, right? So you are receiving that rent as a trustee, as a guardian, or as a receiver. I shall tell you how does it work. Firstly, if I have given my property on rent, I am collecting rent, I am landlord. Secondly, if I'm not getting rent, I am entitled to get rent, I am landlord. Thirdly, I have appointed someone to collect rent on my behalf as a trustee, right? I have appointed someone to collect rent on my behalf as a trustee. So that trustee is also landlord. I am landlord, but along with me, that trustee is also landlord. He shall also enjoy all the rights and liabilities as a landlord under CG Rent Control Act. Then next, on account of or on behalf of any other person, okay, as a guardian or receiver. So again, I am receiving rent on behalf of a minor child as a guardian of that minor child. Let's assume that my father transfers some of his property to my son, right? Now my son is a minor, so I am his guardian, and in that property someone is living on rent, right? So I am receiving rent on behalf of my son, so I am acting as a guardian of that landlord. Okay? Or okay, on benefit, for the benefit of any person, or as a trustee or receiver. Now receiver is appointed by the court. Now let's assume that there is a dispute. There is a dispute going on regarding the ownership of the property. So what the court did temporarily, meanwhile the judgment is pending, the court has appointed a receiver. Mr. A will collect rent or as a landlord of this property. He is acting as a receiver, right? And once the case will be solved, definitely the receiver thing will be adjusted. So at that time, that receiver is acting as the landlord, and he is enjoying all the rights and all the liabilities as a landlord, right? Or who would so receive rent or to be entitled to receive the rent if the accommodation were let to a tenant. So now, next, sixth thing includes yeah. So next thing is okay, who would so receive the rent to be entitled to receive the rent if the accommodation were let to a tenant. So even if I am not using my property in tenancy agreement, but I can do that. Okay, I am empowered to do that. I am having a property, right? And I can let it to someone as a tenant, but I didn't do that, right? So here what will happen, I am enjoying my right as a landlord. It doesn't mean that I have to lease my property to enjoy the rights as a landlord. Even if I haven't let my property, but I am having that authority that I can let my property. So I shall be considered as a landlord. Landlord means who is receiving or entitled to receive rent, receiving rent on behalf of or on account of another person or any other person who would receive the rent if he is going to put the property on rent. Is it clear? Yes or no? Is there any confusion in it?
So the last part you said if any other person
Uh,
were to let, then also he's entitled to receive, right?
yeah.
Oh,
Now, so what they are stating, okay, or who would be so receive the rent to be entitled to receive the rent if the accommodation were let to a tenant. So suppose I am having a house, right? But I haven't let that house to someone. But I am empowered to let that house to someone. This is my house, right? So if I let this house on rent, I shall become a landlord. So I am entitled to become a landlord. That shall also be considered as a I am acting as a landlord of the property, right?
right, sir.
Okay. Now, municipal area and Nagar Panchayat area includes the area defined under Chhattisgarh Municipal Corporation 1956. Notification refers to the relevant notification of the government as published in the official gazette, right? Notification means the notification issued by the government and published in the official gazette. Old Act, wherever you are seeing the term Old Act, it means it is referring to Chhattisgarh Rent Accommodation Control, Chhattisgarh Accommodation Control Act 1961. So basically, Old Act, that is Accommodation Control Act 1961, has replaced the new act, which is Chhattisgarh Rent Control Act 2011. Now, next definition is very important, 29. right? It is talking about rent. Rent means the consideration payable by the tenant to the landlord against the accommodation. Now, remember this thing that the word consideration is derived from the word consider. Consider means giving value or giving weightage to something. So, whatever thing, remember here we are not always talking about financial, right? Whatever thing is provided as a consideration by the tenant to the landlord is rent. By the tenant to the landlord is rent. So let's assume that I'm living in this house, okay, as a tenant, and what I am doing, I am performing some domestic help in the house of the person where I am living and paying 2000 rupees a month as a rent. So here the rent shall include both the things, right? That 2000 rupees plus whatever job I am performing. So rent means the consideration payable by the tenant to the landlord. Against what? Against an accommodation. Accommodation means the premises which has been provided by the landlord. Now, next is rent controller. Rent controller means officer appointed under subsection 1 of section 7. Subsection 1 of section 7 states about who is a rent controller. Now, next is rent control tribunal. It means a body constituted under section 6 subclause 1. Rent controller is appointed under section 7 subclause 1. Rent control tribunal is appointed under section 6 subclause 1. Now, here you have to remember that both of these authorities are the main or the leading authority in this whole act. In this whole act, these are two prime authorities, right? One is rent controller, another one is rent control tribunal. Now, rent control is appointed under section 7 subclause 1 and rent control tribunal is appointed under section 6 subclause 1. Now, repealed act, old act or repealed act means Chhattisgarh Accommodation Control Act 1961. Now, let's understand what is social nuisance. Social nuisance means a tenant who frequently use accommodation to commit any or all kind of things listed under serial 10 of schedule 4. Serial 10 of schedule 4. So all the things done by a person under serial 10 of schedule 4 are considered as a social nuisance. Now, what all things are included here? This is schedule 4, right? Serial 10. That is, social nuisance means doing or causing to be done any of the following act, like drunken bravels, मतलब शराब पी के झगड़ा करना, शराब पी के उत्पात करना, वाइफ बैशिंग, प्रोस्टिट्यूशन, habitual लेट नाइट सोशलाइजिंग, मतलब बीबी के साथ मारपीट या प्रोस्टिट्यूशन की प्रैक्टिस करना या लेट नाइट नॉइजी सोशलाइजिंग या गैदरिंग करना, ठीक है, और क्रिएशन ऑफ एबनॉर्मल नॉइज बाय कंस्ट्रूड बाय द नेबरहुड एज डिस्टरबेंस। कोई भी ऐसी नॉइस निकालना जिससे कांस्टेंट डिस्टरबेंस हो, लाइक हाई वॉल्यूम में गाना चला रहे हो दिन भर, ठीक है, घर के अंदर कथक क्लासेस चला रहे हो जिससे किसी को प्रॉब्लम हो रहा है, राइट? spitting in the common facilities like staircase, storage of any hazardous stuff. That is also social nuisance. Like you are living in a property where multiple people are living and they are using common washroom or common staircase or common balcony, and you are spitting over there, urinating over there, ठीक है, or storage of any hazardous chemical, hazardous element, ठीक है, storage of any stuff which is having offensive odor, any kind of chemical which is having a bad smell, odor, right, that fouls up the surrounding, or that abnormally invites the pests, littering of garbage and letting loose wastewater, spoiling the environment by doing or promoting defecation, and any act that has bad and damaging social effect in the immediate neighborhood. So any act which is inviting the pests, ठीक है, छोटे छोटे कीड़ों को जो इनवाइट कर रहा है, कोई भी ऐसा काम करना, लेटरिंग ऑफ गार्बेज, गार्बेज को खुले में डंप करना, ठीक है, लेटिंग लूज वेस्ट वाटर को लूज आउट कर देना, राइट, गटर लाइन डैमेज हो गई है, यू आर नॉट टेकिंग केयर ऑफ इट, so it is generating unpleasant odor also, ठीक है, doing something which is affecting the environment like open defecation, or any act which is creating bad impact in the society. So all of these acts are categorized as a social nuisance. I hope this thing is clear to all of you what is social nuisance.
Yes.
Yes.
Yes, sir.
Now heading next, tenant. Who is a tenant? So as per section 2 clause 14, now remember that these clauses you have to mug up, you have to remember, right? Tenant, tenant means the person by whom or in whose account or on whose behalf the rent is, or but for a contract express or implied would be payable for any accommodation to his landlord. So tenant shall include any person who has to pay rent or on whose behalf the rent is payable, right? That person shall be considered as a tenant. As we have understood, landlord means the person who can collect rent, who is entitled to collect rent, collecting rent, or who has empowered someone to collect rent on his behalf. In the same way, if I am living on this property, like in this property on rent, and I have empowered someone to pay rent on my behalf, so that person shall also act as a tenant for that landlord, including the person who is continuing its possession after the termination of his agency. So let's assume that I have signed a contract of like agreement of rent for 11 months, right? The period was getting over on 1st January 2025, but I continued living ahead of that in the same house. So even though I'm not having any rent agreement, still I shall be considered as a tenant for the purpose, right? Now I will tell you in this tenant definition, mostly tenant की definition से question बनता है, right? And specifically stating point A और B से बहुत questions बनते हैं, ठीक है? Otherwise then by an order or decree of eviction passed under the provision of this act. If the decree of eviction or order of eviction has been passed under this act, still someone is continuing his possession, then he is not tenant. Otherwise, if the case is pending in the court and the person is living over that property as a tenant, and the tenancy or the rent agreement period is over, right, then also even if that period is over, still that person shall be considered as a tenant. Now the tenant shall include these other people in case of accommodation let out for residential purpose. Like suppose I have given my house to someone as an accommodation for residence purpose for living, his surviving spouse, right? Let's assume that the rent agreement is on wife's name or on husband's name. So the surviving spouse, like in case of the death of that person, right? In case of death of my tenant, his wife, or in case of she is a female, her husband. Ordinarily, son, daughter, mother and father who had been ordinarily residing with him in such accommodation as a member of his family up to his death. Now remember this thing, that always husband, wife, son, daughter shall not become tenant. They will become automatically tenant only when they were living with that person, when that person died. As a teenage, when that person died, these people like spouse, son, daughter, father, mother, ordinarily they were living with that person. So these people will automatically become tenant. If my wife is not living with me, she is living somewhere else, and I am living over this property, which is a rented property, and if I expire, then in that case my wife shall not automatically become tenant. Now, in case of accommodation let out for commercial or business purpose, so this definition is for residential purpose. Now let's assume that I have given a shop on rent, right? And again the same thing happened, that the tenant has expired. Then his surviving spouse, son, daughter, mother or father who had been ordinarily carrying on business with him in such accommodation as the member of his family at the time of his death. So the people, the family members, like the son, like the daughter, the father, mother, surviving spouse, in case of deceased tenant, they were living along with the, they were operating the business along with the tenant. So all of these people will be considered as a tenant. Is it clear? Yes or no? Yes, the definition of tenant is clear. Please just let me know. Yes, sir. Okay. Now, let's understand the exemption. If you remember, I was stating you, I have clearly stated you, even though there are certain property which are not, which are residential or non-residential, right? But they didn't fall in the category, they didn't covered by Chhattisgarh Rent Control Act. Why? Because if any kind of property is owned by the government, okay, any property is owned by the government or department of government, like there is a building, नगर निगम का बिल्डिंग है, राइट, या किसी भी बोर्ड या कॉर्पोरेशन उसको बिल्डिंग को ऑपरेट कर रहा है, कोई भी बोर्ड और कॉर्पोरेशन, उस बोर्ड और कॉर्पोरेशन को चला कौन रहा है? गवर्नमेंट. तो इन सिंपल पे ऑल द गवर्नमेंट इंस्टीट्यूशन प्रॉपर्टी, ठीक है, इट कैन बी गवर्नमेंट रेजिडेंशियल सोसाइटी, इट शैल इंक्लूड लाइक द गवर्नमेंट जजेस को जो क्वार्टर्स मिलते हैं, बंगलोज मिलते हैं, ऑल दैट, ठीक है, ये सब किसमें, ये इस छत्तीसगढ़ रेंट कंट्रोल एक्ट के अंदर गवर्न नहीं होगा, right? Secondly, any other building or the category of building specifically exempted in public interest. ये word याद रखना, public interest बहुत important है. छत्तीसगढ़ रेंट कंट्रोल एक्ट में एक क्वेश्चन ये भी बनता है एग्जाम्पशन में, कि any other building specifically exempted in like educational purpose, social purpose, cultural purpose, public interest. So you have to remember which has been like specifically exempted in public interest by the government through notification. So the government has passed a specific notification that this particular property is exempted due to public interest, right? So government ka property plus any property which the state government by notification exempt. When I'm saying government ka property, it shall include both residential and non-residential property. It shall include all the property which has been operated by, which is being managed or controlled by the board, which is backed by the government, right? Or the corporation, which is backed by the government, or any department of government. So, exemption clauses are clear, yes or no? हाँ या ना भाई, जल्दी से बताइए, फिर आगे बढ़ेंगे. Yes.
Yes, sir.
Okay, perfect. Now, tenancy agreement. What is tenancy agreement? Remember that as per section 4 defines tenancy agreement. Notwithstanding anything contained in section 107 of Transfer of Property Act, Central Act number 4 of 1882, no person shall, after the commencement of this act, take or let or rent any accommodation except by an agreement in writing. So, सबसे पहली चीज, as per CG Rent Control Act 2011, if someone wants to let or put his property on tenancy, it can be done only by written agreement. It cannot be done by verbal communication. It should be done by an agreement, and that agreement should be signed as per the provision of Chhattisgarh Rent Control Act. Now, wherein in relation to any tenancy created before the commencement of this act, like any tenancy has been created before 2011, then an agreement in writing was already entered, it shall be filed before the rent controller. So if before the enactment of this law or this particular act, if there was an agreement between landlord and tenant, they were having an agreement and that agreement was in writing. So you can file the copy of that written agreement to make it correspondence with the provision of CG Rent Control Act, right? And in case अगर कोई written agreement नहीं था, there was no written agreement, तो आपको क्या करना पड़ेगा? लैंडलॉर्ड और टेनेंट को एक written agreement में enter करना पड़ेगा, right? And they have to file that document before rent control. आसान भाषा में, अगर इस एक्ट के बाद आप कोई भी रेंट अग्रीमेंट बना रहे हो तो रिटन अग्रीमेंट बनाओ, रेंट कंट्रोलर के पास जाके फाइल। सेम चीज है, अगर इस एक्ट के आने से पहले आपका कोई रिटन अग्रीमेंट था, उसको रेंट कंट्रोलर के सामने जाके फाइल कर दो, नहीं था तो रेंट अग्रीमेंट बनाओ और उसे ले जाके रेंट कंट्रोलर के सामने फाइल कर दो, ठीक है। अब provided that where the landlord and tenant fails to present jointly a copy of tenancy agreement under clause A or fails to reach to the agreement under clause B, such landlord and tenant shall separately file particulars about such tenancy. Now let's assume कि clause A या clause B के अंदर, right, एक जो रेंट अग्रीमेंट था बिफोर द इनेक्टमेंट ऑफ दिस एक्ट बना हुआ था या नहीं बना हुआ था, लेकिन अभी वो जो लैंडलॉर्ड है और टेनेंट है उनके बीच में कुछ डिस्प्यूट चल रहा है एंड दे आर नॉट ऑन द सेम पेज, दे आर नॉट ऑन द सेम पेज। तो अपना अपना वर्जन ऑफ द स्टोरी, अगर आप टुगेदर फाइल नहीं कर पा रहे हो तो अपना अपना वर्जन ऑफ द स्टोरी यू हैव टू फाइल इन द ऑफिस ऑफ रेंट कंट्रोल। मान लीजिए अगर ज्वाइंटली दोनों एक चीज पे नहीं है, दे कैन नॉट प्रेजेंट इट ज्वाइंटली, राइट, और छत्तीसगढ़ रेंट कंट्रोल एक्ट के अंदर दे हैव टू फाइल इट टुगेदर। अब यहां टुगेदर फाइल करने का ऑप्शन नहीं बचा बिकॉज दे आर नॉट अग्रीइंग ऑन द सेम थिंग इन द सेम सेंस, सो दे कैन फाइल इट सेपरेटली बिफोर द रेंट कंट्रोल, ठीक है। अभी हम आगे की प्रोसेस पढ़ेंगे। रेंट कंट्रोलर ऐसा नहीं है कि जो भी आपने बोल दिया उसको मान लो, ठीक है। the rent controller gonna check each and everything, right, and then he shall settle down the terms of rent agreement. Now every agreement referred in subsection 1 or required to be executed under subsection 2 shall be in such format and manner as prescribed within such period as may be prescribed. So at the end of this act आपको एक क्लॉज मिलेगा जिसमें ये चीज लिखा है कि द रेंट अग्रीमेंट शुड बी प्रिपेयर्ड विद इन dash days of entering into the rent agreement, or in case if the rent agreement is continuing before the execution of this particular act or before the commencement of this particular act, then within X days of filing the act you have to enter into the agreement and you have to make it a writing and have to file it before the rent control. Now rent to be as agreed. Now what is rent? So As per section 5, rent is the rent payable for any accommodation shall, subject to the other provision of this act, be such as may be agreed between the landlord and tenant, and it shall not include charges payable for amenities which is agreed on upon separately and shall be paid accordingly. Now, rent should be the amount which has been mutually agreed between the landlord and tenant, right? लैंडलॉर्ड और टेनेंट के बीच में जो म्यूचुअल अग्रीमेंट हुआ है वो अमाउंट शैल बी फिक्स्ड एज अ रेंट. बट इफ लैंडलॉर्ड स्टेटेड दैट आई एम प्रोवाइडिंग यू गीजर, ठीक है, गैस गीजर, ठीक है, इन विंटर्स, so I gonna charge additional 200 per month for geyser during winter period. So that amount cannot be included as a rent, or it can be concluded as a rent. That is the amount payable separately. Okay, for the amenities which you are enjoying. And unless agreed otherwise, every tenant shall pay the rent on the 15th of the month next following the month on which rent is paid. So जैसे जनवरी का rent है, that has to be paid by 15th Feb. February का rent है, it should be paid on 15th March and so on. So either they have mutually decided a date कि like 7th day of next month पे आप पे करेंगे, or if they haven't mentioned anything about this thing, when the tenant has to pay the rent to the landlord, and in that case it shall be 15th of the following month. Right? Clear? Now, constitution of rent control tribunal. रेंट कंट्रोल ट्रिब्यूनल कैसे बने, ठीक है? द स्टेट गवर्नमेंट शैल, पहला क्लॉज आपको याद रखना है, द स्टेट गवर्नमेंट शैल कॉन्स्टिट्यूट और फॉर्म रेंट कंट्रोल ट्रिब्यूनल within 30 days of this act, within 30 days of passing of this act. These two are questions important from prelims perspective. A tribunal in terms of Article 323B of Constitution of India is called Chhattisgarh Rent Control Tribunal. To give effect to the provision of this act and for adjudication or trial of any dispute, complaint or offences relating to rent, its regulation, control and tenancy issues including right, title, obligation of landlord and tenant. So basically जो rent control tribunal है, it shall be established within 30 days of passing of this act by the state government as per Article 323 clause B of 323B of Constitution of India. It shall adjudicate and decide all the matters regarding the payment of rent, rights, titles, obligation between landlord and tenant. Now, explanation. Matters referring to transfer of property or dispute regarding title over any property shall continue to consider under relevant law by the court. So, if there is any dispute regarding transfer of property or any dispute regarding title over that property, that shall not be governed by, or that shall not be decided by rent control tribunal. Rent control tribunal is going to deal only with the cases related to rent or the cases related to tenancy, right? The state government shall appoint the chairman of rent control tribunal, a retired judge of high court, or the serving or retired judge of district court not below the rank of super time scale. So basically, the retired judge of high court, okay, is gonna be the chairperson, or the serving or retired judge not below the rank of super time scale. What is super time scale? Super time scale shall be prescribed by the state government in its notification. These are the qualification for super time scale, right? Now, the tribunal shall have such members with qualification as the state government may prescribe. How many members that will be there? It is not decided by the act. It shall be the number of members as decided by rent control by state government. Right? The rent control tribunal shall have such number of people as a member as decided by state government. The state government shall appoint an officer of registrar of tribunal who is not below the rank of the cadre of civil judge class 1 or rank of deputy secretary of state government. That clause is not that much important. Heading towards next. From the date the tribunal becomes functional, which date shall be published in the state gazette after passing of this act. Right, after passing of this act, the tribunal shall be established within 30 days, and then the state government has to notify in its official gazette from which date this particular uh, rent control tribunal is actionable or functional. Okay, the jurisdiction of all the courts except the jurisdiction of Supreme Court under Article 136 and High Court under Article 226 of Constitution of India shall stand excluded in respect to all the matter falling within the jurisdiction of the tribunal. तो सिंपली हाई कोर्ट और सुप्रीम कोर्ट को छोड़ के कोई भी रेंट से रिलेटेड मैटर है, पहले आप रेंट कंट्रोलर के पास जाएंगे. इफ यू आर नॉट सेटिस्फाइड यू विल रीच टू रेंट कंट्रोल ट्रिब्यूनल. रेंट कंट्रोल ट्रिब्यूनल से सीधा अपीलेट अथॉरिटी कौन सी होगी? हाई कोर्ट. रेंट कंट्रोल ट्रिब्यूनल से अगली अपीलेट अथॉरिटी इज गोना हाई कोर्ट. Provided, however, that all cases pending before any court or authority immediate before the establishment of tribunal shall continue to proceed to be processed under the old act as amended from time to time. So the cases pending under PG Accommodation Control Act 1961, right? Those cases shall be decided by the rent controller established under that. But if any new case is coming after the commencement of this act, so it is not having ex post facto effect, right? Or you can say it is prospective law. It is not retrospective. It shall apply on the cases which are coming after the commencement of this act. Its headquarters is gonna be at Raipur. Okay? And the state government may by its notification fix such other places of hearing of matter of tribunal as it deems. Headquarter कहाँ होगा? रायपुर में. But the state government can fix any other place for hearing as it deems fit. Now, the terms and conditions of service of chairman and member of tribunal shall be such as may be prescribed by the state government. Now, अगर हम मोटा मोटा बात करें, ये तो हमने प्रोविजन समझ ली. अब अगर हम प्रोविजन के बारे में बात करें तो रेंट कंट्रोल ट्रिब्यूनल 30 दिन के अंदर अंदर स्टैब्लिश हो गया आफ्टर द कमेंसमेंट ऑफ दिस एक्ट. पहली चीज. दूसरी चीज ये केवल टेनेंसी से रिलेटेड मैटर देखेगी. तीसरी चीज ये आर्टिकल 323 क्लॉज बी के अंदर बनी है. चौथी चीज इसके पास जो जुरिस्डिक्शन है वो हाई कोर्ट और सुप्रीम कोर्ट को छोड़ के बाकी सभी कोर्ट्स के ऊपर है. मतलब इस ट्रिब्यूनल के अगेंस्ट अपील होगी बाय द अग्रीड पार्टी इन हाई कोर्ट. सिंपल. ठीक है. ट्रिब्यूनल का हेडक्वार्टर रायपुर में होगा. ठीक है. ट्रिब्यूनल का जो जज होगा वो रिटायर्ड जज ऑफ हाई कोर्ट होगा या एग्जिस्टिंग जज ऑफ डिस्ट्रिक्ट एग्जिस्टिंग डिस्ट्रिक्ट जज और रिटायर्ड डिस्ट्रिक्ट जज ऑफ सुपर टाइम स्केल का होगा. क्लियर है? ये बातें थी जो आपको इसके अंदर जानने की जरूरत थी. और एक और चीज है जो इंपॉर्टेंट है कि भैया ये जो रेंट कंट्रोल ट्रिब्यूनल ये ओल्ड केसेस को नहीं देखेगी. छत्तीसगढ़ अकोमोडेशन कंट्रोल एक्ट के अंदर ये जो केसेस है उसको छत्तीसगढ़ रेंट कंट्रोल ट्रिब्यूनल नहीं देगी. क्लियर है यहां तक? यस और नो? टेल मी.
Yes, sir.
Now, next. Establishment of rent control. For every district, the state government shall appoint one or more officer not below the rank of deputy collector. So, rent controller for each state or group of state, there is gonna be a rent controller who is not below the rank of deputy speaker, right? And his jurisdiction shall be decided by the district collector. रेंट कंट्रोलर शैल बी सबऑर्डिनेट टू रेंट कंट्रोल ट्रिब्यूनल। तो इसकी सबसे जो छोटी यूनिट है दैट इज रेंट कंट्रोल, ठीक है। उसके ऊपर आ गई आपकी रेंट कंट्रोल ट्रिब्यूनल, ठीक है। उसके ऊपर आ गया हाई कोर्ट, right? That is gonna be the hierarchy. So today we will stop here till section 7, and I am not taking MCQs today. Reason behind, I want you people to firstly follow it, right? आप लोग रिवीजन करके आइए, क्लॉजेस को क्लियर करके आइए, ठीक है। कॉन्सेप्ट आपको क्लियर हो ही गए हैं, केवल क्लॉजेस को क्लियर करने की बात है। आप क्लॉजेस को क्लियर करके आइए। कल की क्लास में हम लोग शुरुआत करेंगे पहले एमसीक्यू से, राइट? इज इट क्लियर? बिकॉज इसमें
Yes,
आपको
sir.
थोड़ा सा मगअप करने के लिए टाइम चाहिए, राइट?
Okay, sir.
ओके,
Sir, you are referring to which barrack?
आई एम रेफरिंग टू छत्तीसगढ़ रेंट कंट्रोल एक्ट 2011 में।
Which publisher, sir?
It is like, if I'll show you. This is, I'll just share the link of this Bear Act also. It is the official Bear Act, right? छत्तीसगढ़ भाड़ा नियंत्रक अधिनियम 2011, that is published in the official gazette of Chhattisgarh, right?
Okay, sir. Not any physical one if you are referring any.
No, physically I'll tell you, I'll show you. It is of Vadhva publication, right? Because it's a local law, तो universal वगैरह का आता नहीं है, तो Vadhva publication I am referring. Fine?
Okay, sir.
Thank you so much, people. See you in tomorrow's class.
Thank you, sir.
Thank you, sir.